In the federal court system of the United States, in any given year, approximately 96% of criminal fraud cases that result in a conviction do so through a guilty plea, not through a trial. Of the 4% that go to trial, the vast majority involve defendants whose alleged thefts are under $1 million. The cases involving the largest dollar amounts, the multi-million-dollar fraud cases, the cases that draw newspaper headlines when they are first announced, almost never see a jury. They settle. They plead. They disappear into administrative agreements signed in conference rooms with the press locked outside. This is not because the largest frauds are the easiest to prove. It is because the largest frauds are the most expensive to prosecute. And in 2019, a $40 million fraud committed by a man named Russell Cain Beaufort, a real estate investment manager in Charleston, South Carolina, became the textbook example of how this works. This is the story of $40 million, 311 defrauded investors, and a courtroom that never opened. Let me give you 4 examples before we go into the Beaufort case, because the pattern is the part of the story that matters most. In 2015, an investment manager in Phoenix, Arizona named Calvin Tatum was indicted on federal charges of operating a Ponzi scheme that defrauded approximately 180 retirees out of a total of $27 million. The case did not go to trial. Tatum entered a guilty plea in exchange for a sentence of 6 years, restitution to be paid through future earnings, a provision that, given the dollar amount and Tatum's age, was essentially symbolic, and the dropping of additional charges that had carried potential sentences of up to 25 years. In 2017, a brokerage firm executive in Denver named Myra Halverson was charged with running a securities fraud that had cost her clients approximately $34 million over an 8-year period. The case did not go to trial. Halverson pleaded out, paid $8 million in agreed-upon civil penalties, sourced largely from the proceeds of the fraud, which she had not been required to disgorge in full, and received a 4-year sentence. In 2018, a private equity manager in Charlotte named Hugo Reinhardt was charged with diverting $46 million from a fund he managed into a personal trust over 6 years. The case did not go to trial. Reinhardt settled the civil action with the SEC, paid a fine, and was barred from the securities industry. The criminal case was deferred under a non-prosecution agreement contingent on his cooperation with ongoing investigations. In 2019, Russell Cain Beaufort, who is the central figure of this story, was charged with operating a real estate investment fraud that had cost 311 investors a total of approximately $40 million. The case did not go to trial. The reasons it did not go to trial are the reasons cases of this scale almost never do. This is the pattern. The pattern is not coincidence. The pattern is structural. The structure is the story. Russell Cain Beaufort was 61 years old when the federal charges against him were unsealed in the spring of 2019. He was a 4th-generation Charlestonian. His great-grandfather had been a cotton merchant. His grandfather had been a banker. His father had been a real estate developer who had, in the 1970s and 1980s, built a substantial portfolio of mid-rise commercial properties in the Charleston Historic District. Russell Beaufort had inherited the family firm in 1995 and had spent the next 2 decades transforming it from a property development business into an investment management firm, one that solicited investments from individuals, principally local and regional retirees, to be deployed in real estate transactions that the firm structured and managed. The firm was called Beaufort Heritage Holdings. Its offices occupied the 2nd and 3rd floors of a renovated 19th century building on East Bay Street. Its lobby was, by every account, an exercise in Old South investment firm aesthetics: dark wood paneling, brass fixtures, a portrait of the founder above the receptionist's desk, a small library of leather-bound books no client had ever opened. The receptionist, a woman named Glenda Boatwright, who had worked for the firm for 27 years, was on a first-name basis with most of the firm's clients. The clients were, in many cases, 2nd and 3rd generation patrons, adult children and grandchildren of investors who had been with Beaufort Heritage since Russell's father was running it. This was the trust environment in which the fraud operated. Russell Beaufort had been, by external evaluations, a successful investment manager for approximately the first 15 years of his tenure. The firm's audited annual reports through 2010 showed returns that were modest but consistent. slightly above the inflation rate, slightly below the broader market, which is precisely what conservative retiree investors look for. The reports were prepared by a respected regional accounting firm. They contained no obvious irregularities. The fraud, as the federal investigation later established, began in 2011 and ran for approximately 7 years before it was uncovered. The fraud Russell Beaufort operated was, in structural terms, a variant of a classic Ponzi scheme, but with a real estate wrapping that made it considerably more durable than the financial instrument frauds that more typically come to light. Beaufort solicited investments for what he represented as specific real estate development projects in the Charleston region. Investors received documentation describing the project, the projected returns, the timeline, and the structure of the investment vehicle. The documentation was professional. The projects, in some cases, even existed. There were specific parcels of land and specific permits filed with the city. What did not exist were the development plans Beaufort had represented to investors. The land sat undeveloped. The permits expired. The investor funds, rather than being deployed into the projects, were either routed to Beaufort's personal accounts, used to pay earlier investors their promised returns, or held in operational accounts to maintain the appearance of an active investment management firm. The system Beaufort built was sophisticated enough to survive multiple external audits. The auditing firm, working from financial statements that Beaufort and his small accounting staff prepared, was not in a position to independently verify whether the underlying real estate projects were actually being developed. The auditors examined balance sheets and income statements. The balance sheets showed assets in the form of land holdings which existed and could be verified. The income statements showed returns being distributed to investors, which they were. The returns were just being paid from new investor money rather than from project earnings. The audit process did not, in its standard scope, require the auditors to drive out to the construction sites and confirm that construction was happening. This is one of the structural features that makes large real estate fraud particularly durable. The verification of a real estate project requires physical and temporal verification that auditing standards do not require auditors to perform. The land exists on the deed, the plans exist on file. Whether the project is actually proceeding is a question auditors are not equipped or required to answer. The Beaufort fraud was eventually exposed not by an auditor, not by a regulator, not by a tipster. It was exposed by a death. In late 2017, one of the firm's larger investors, a 78-year-old retired pediatrician named Dr. Wilhelmina Sutter, died. Her estate, managed by an attorney in Atlanta, who was reviewing the deceased's holdings to prepare for distribution to her heirs, examined Dr. Sutter's investment portfolio and noticed that approximately $3.1 million was invested in a Beaufort Heritage Holdings real estate fund focused on a specific development project in North Charleston. The attorney, conducting due diligence as part of the estate's administration, attempted to verify the status of the project. He drove out to the property address. The property was undeveloped. The land was overgrown. There were no construction trailers, no fencing, no signage, no evidence that any development activity had occurred or was occurring. The attorney requested additional documentation from Beaufort Heritage Holdings. The documentation he received described the project as being in a pre-construction permitting phase, which the attorney noted was inconsistent with the fund's filing documents from 3 years earlier, which had described the project as expected to be substantially complete by the time of Dr. Sutter's death. The attorney filed a complaint with the South Carolina Securities Division in February 2018. What followed is the part of the story that illustrates where the system failed in the more meaningful sense. The Securities Division acknowledged the complaint. They opened a preliminary review. The preliminary review identified that the situation warranted formal investigation. They referred the matter to the SEC, since the fraud appeared to involve federally regulated securities. The SEC opened its own preliminary review. The SEC's preliminary review took 6 months. During those 6 months, Russell Beaufort continued to operate. He continued to accept new investor funds. He continued to issue distribution payments to existing investors. The fraud, in dollar terms, grew by approximately $7 million between the date of the initial claim and the date the SEC issued its first subpoena. The system's procedures for investigating financial fraud do not include any mechanism for halting the underlying business activity during the investigation. There is a legal reason for this. Pre-investigation seizure of business operations would constitute a deprivation of property without due process. There is also a practical consequence. The fraud kept generating victims while the investigators figured out whether it was a fraud. I want to talk about 3 specific people who lost money to Russell Beaufort, because the consequence portion of this story cannot be told in abstracts. The first is a man named Calvin McRae, 67 years old at the time the fraud was exposed. He had been a high school football coach for 31 years in a small town in the Charleston area. He had retired in 2014. He had invested approximately $800,000 with Beaufort Heritage Holdings over a 3-year period. His entire retirement savings, the inheritance from his mother's modest estate, and a small life insurance payout from the death of his wife in 2012. He had been introduced to the firm by his pastor, who was himself an investor. Calvin McRae told a journalist in an interview given in 2020 that when he was first informed of the fraud, he had not understood what was being explained to him for approximately 20 minutes. He had thought there was a paperwork issue that would be resolved. The second is a woman named Felicia Coleman Brown, 58, who had invested approximately $1.2 million from a personal injury settlement she had received after a workplace accident left her partially disabled. The accident had ended her career as a registered nurse. The settlement was, by every reasonable measure, the foundation of her financial security for the rest of her life. She had been introduced to Beaufort Heritage Holdings by her financial advisor, who had received a referral fee for the introduction and who had not, his own attorney later argued, been in a position to know that the firm was operating fraudulently. The third is a married couple, Walter and Eleanor Paquala, who had invested $2.7 million over 6 years. They were in their early 70s. They had built a small commercial cleaning business over 3 decades and had sold it in 2009 to fund their retirement. The Beaufort firm had been recommended to them by Eleanor's brother, who had been a client for decades and who had received consistent distributions for years, and who, when the fraud was exposed, had to be told by his sister that the money he had invested and the money he had recommended his sister and her husband invest was almost entirely gone. The total loss across the 311 defrauded investors was approximately $40 million. The recovery, after the fraud was exposed, after the federal investigation, the SEC enforcement action, the civil litigation, the bankruptcy of the firm, and the criminal proceedings, was approximately $3.8 million. Not $3.8 million per investor, $3.8 million total. The average investor recovered approximately 12 cents on the dollar. This is the chapter the title of this video promised. We have arrived at it. When the federal charges against Russell Beaufort were unsealed in May 2019, the indictment contained 21 separate counts. The lead prosecutor on the case was an assistant U.S. attorney named Daniel Velez, with 11 years of experience prosecuting white-collar fraud cases. Velez told the press, on the day the indictment was announced, that the office intended to aggressively prosecute the case. Within 11 months, Russell Beaufort had agreed to a plea deal. He pleaded guilty to 4 of the 21 original counts. He was sentenced to 8 years in federal prison. He agreed to forfeit approximately $7 million in personal assets, though some of those assets, when actually liquidated, returned considerably less than the $7 million figure suggested. He agreed not to contest the SEC's parallel civil enforcement action, which resulted in an order to pay restitution that he was, given his net worth at the time of plea, in no position to actually pay. The Beaufort case did not go to trial for the same reasons cases of this scale rarely do. There are 5 of them, and they operate together. First, the prosecution costs would have been enormous. A fraud case of this scope, involving 311 victims, 7 years of fraudulent activity, and the financial records of a multi-million-dollar operation, would have required prosecutors to present months of testimony and tens of thousands of pages of exhibits to a jury. The U.S. Attorney's Office for the District of South Carolina had a finite budget. A trial of this scope would have consumed a substantial portion of that budget for the better part of a year. The plea deal preserved those resources for other cases. Second, the conviction was effectively certain through plea, but not certain through trial. Federal fraud cases at trial have lower conviction rates than the public assumes. partly because juries struggle with complex financial evidence. A jury hearing about real estate development funds and audit procedures for 6 weeks is not the audience prosecutors prefer. The plea guarantees a conviction. A trial introduces risk. Third, the victims wanted restitution. The criminal case by itself did not produce restitution. The federal government does not pay victims back. The civil case, which ran in parallel, did produce some restitution, but only insofar as Beaufort still had assets to seize. Prosecutors and victims' counsel had a shared interest in resolving the cases efficiently so that asset seizure could proceed and partial restitution could be distributed. A multi-year trial would have delayed restitution by years. Fourth, the plea deal eliminated appeals. A defendant convicted at trial can appeal. A defendant who pleads can typically only appeal procedural questions, not the underlying conviction. The plea closed the matter definitively, which mattered both to prosecutors, who did not want to risk reversal years later, and to victims, who did not want to wait through an appeal cycle. Fifth, and most importantly, the political economy of white-collar prosecution does not reward trials. Career advancement for federal prosecutors comes from conviction rates and case clearance. A trial that takes a year and ties up a prosecutor's entire docket produces one conviction. The same year of prosecutor time devoted to plea deals on multiple cases produces several. The internal incentives of the U.S. Attorney's Office push toward settlement. The 4 largest financial frauds I described at the beginning of this video, Tatum, Halverson, Reinhardt, Beaufort, all ended the same way. They did not end the same way because the defendants were uniformly guilty and the plea was uniformly appropriate. They ended the same way because the system that prosecutes fraud of this scale is structurally configured to produce that outcome. Calvin McRae, the retired football coach, lost approximately $704,000 of his $800,000. He moved back in with his adult son in 2020. He works part-time at a sporting goods store in his town. He has said publicly that he does not blame Russell Beaufort the man because, in his words, Russell Beaufort the man is in prison. I have to blame something I can actually do something about. I blame the system that lets these things happen for 7 years before anyone notices. Felicia Coleman Brown lost approximately $1,056,000 of her $1.2 million. The remainder, combined with disability income and a hardship distribution settlement from the SEC's Victim Recovery Fund, provides her with a modest income for the rest of her life. She lives in a small apartment in North Charleston. She no longer uses a financial advisor of any kind. She has, she said in an interview, trusted my last professional. I will manage my own money for what is left of my life. Walter and Eleanor Pakwala lost approximately $2.38 million of their $2.7 million. They moved into a smaller home in 2021. Their daughter and her husband helped them with the move. Eleanor's brother, who had recommended the investment, has not been to a family function since the fraud was exposed. The relationship, by Eleanor's account, is not formally broken. They speak on holidays, but it is not what it was. He is not at fault, Eleanor said in an interview. But we cannot sit at a table together without thinking about it. So we have not sat at a table together for 4 years. These 3 investors are part of a group of 311. The other 308 have their own versions of the same outcome. There is no public registry of them. There is no annual report on their condition. There is, for most of them, no ongoing connection to the case or the institutional system that processed the case. They are, in the strict sense, finished with it. The case is closed, the fraud is documented. The fraudster is incarcerated. The system has moved on. I want to end this not with a moral. I want to end it with a specific architectural observation. The Beaufort case did not happen because the system failed to detect a small-scale fraud. It happened because the system is calibrated to detect small-scale fraud first, and large-scale fraud only after considerable delay. Audit procedures focus on transactions. Investigators focus on complaints. Regulatory triggers focus on patterns visible in aggregate data. None of those tools, audit, complaint, pattern detection, are designed to identify a fraud whose underlying assets are physical real estate that can be visited but is not. None of them ask the question that Dr. Sutter's estate attorney asked when he drove out to the development site. Is the project actually happening? That question, asked once by one person 3 months after the fraud's primary victim had died, ended a 7-year fraud. The question is not a particularly sophisticated question. The system did not ask it because the system does not have a procedure for asking it. The system has procedures for verifying that documents exist. It does not have procedures for verifying that the things documents describe exist. That gap is the structural feature that makes large real estate fraud durable. It is also the gap that will be there next year, and the year after that, and the year after that. There will be another Beaufort case. We will know the name in 3 or 4 years. The number will be different. The victims will be different. The case will not go to trial. The reasons it will not go to trial will be the same 5 reasons this one did not. The pattern is not a coincidence. The pattern is the design. The development site in North Charleston where Dr. Sutter's $3.1 million was supposed to have built a 68-unit residential complex is still undeveloped. A real estate sign faded by 10 Carolina summers hangs on a fence post at the edge of the property. The sign says, "Coming soon, a new vision for downtown living." The phone number listed on the sign is no longer in service. The website printed beneath the phone number has been parked. Behind the sign on land Russell Beaufort told 311 people he was developing. A field of broomsedge grows undisturbed each spring and dies down each winter, as it has for 50 years, as it would have whether he had ever called the project anything at all.